a Barclay Damon Live broadcast where we discuss all things L&E, labor, and employment. I'm Ari Kwiatkowski. Let's dig in. Hey everyone, welcome to episode 54, New Laws Pump Up Protection for Nursing Employees. Last week we talked about the Pregnant Workers Fairness Act. Today we're going to talk about the counterpart or analog to that statute, which is the Pump Act. Both of those laws were passed at the same time, December 29th, 2022, as part of the Consolidated Appropriations Act. So let's talk about a little bit about where we were and where we're going, what these new laws say. And in addition to the Pump Act, which is a federal law, I will also give you guys an update on the New York labor law, because if you're an employer in New York State, you know that New York has a pretty broad lactation accommodation policy as is written, but New York made some recent changes that actually expand those protections as well. So we will first dig into the federal laws, and then we will do a primer on New York State law. So let's get right to it. I think it's helpful for me to provide a little bit of context. Again, if you're an employer, you've probably been dealing with these issues for quite some time, especially if you're an employer with over 50 or more employees, and we'll talk about that in a minute. But back in 2010, Congress passed the Break Time for Nursing Mothers law. That law amended the Fair Labor Standards Act, which is a federal statute, to require employers to provide a reasonable break time, to express milk for a nursing child for employees in the workplace for 1 year after the child's birth, and a private space to do so. So basically back in 2010, Congress enacted this law, which did require employers to provide employees reasonable break times in a private space other than a bathroom in which to express milk. So this law was groundbreaking at the time, but there were some limitations. The law, and I'm talking about the Break Time for Nursing Mothers law, did not require employers to provide extra breaks for pumping, but if employers allowed employee break time, then the employer had to allow an employee who was lactating or expressing milk to do so using their break time. This point is really important. This statute actually only applied to non-exempt employees under the Fair Labor Standards Act. So if you have a diverse workforce where you have supervisory, non-supervisory employees who are in administrative or management roles, the prior law only applied to non-exempt employees. So I think that's super important to point out. And the prior law had a little bit of an exception or carve out. It applied to employers with less than 50 employees, unless the employer could establish that the law would impose an undue hardship. So basically, if you had less than 50 employees under the prior law, you could get around the law's requirements if you could show undue hardship by having to comply with the law. Obviously, undue hardship, as we talked about many times on the podcast, is a very fact-specific inquiry. It's an analysis which considers the size of the employer, the financial means of the employer, and the nature of the business. So, that's basically a rundown of the prior federal law. A good start, arguably, but I think there were some limitations, and as a result of those limitations, enter the Pump Act. As I mentioned a few minutes ago, this is a new federal law which was enacted or approved at the end of December, and it actually goes into effect April 28th of this year. So we still have a little bit more time if you're an employer to kind of take a look at the new law and learn what you need to know. So the Pump Act, which stands for Providing Urgent Maternal Protections for Nursing Mothers Act, is an amendment to Section 18D of the Fair Labor Standards Act, and it's enforced by the Department of Labor. And I wanted to mention that a lot of the information that I have gotten to counsel clients on this new law, and which I put together for the podcast today, came from the DOL's website. The DOL had a fact sheet for the Break Time for Nursing Mothers law. It's updated that fact sheet and incorporated what you need to know about the Pump Act. So highly recommend, if you have questions, definitely take a look at that fact sheet. It's very, very helpful. So let's talk about why the Pump Act is different than the prior law. And I think the first thing that I need to mention, or one of the first or most significant reasons why it's different, is because it applies to exempt and non-exempt employees. So The Pump Act provides protections for salaried and non-salaried employees. As some examples, nurses, teachers, managers, supervisors, agricultural workers. So it definitely expands the protections that were available under the Break Time for Nursing Mothers Law. And I did want to I'll note briefly that there are some exceptions for airline workers and railroad workers. So those exceptions are specifically noted in the statute. So it's not necessarily all encompassing, but certainly provides or covers more industries and more employers than the prior law. Another thing I wanted to mention is that this actually expands the time that these protections are available in the workplace. So under the prior law, there was a 1-year period after the child's birth. Under the new law, it's a 2-year period starting at the time the circumstances related to the need to pump arises. So if you think about that, if you're going 1 year from the child's birth, it would start right from the birth. And if you're taking a few weeks of maternity leave or 12 weeks or whatever, that's kind of being counted against you. This is an expanded period of time, and it really starts at the time the circumstances related to the need to pump arises. So, if you are taking maternity leave, that really could be the time period could start when you come back from maternity or paternity familial parental leave. One thing I wanted to point out about the Pump Act too is that it applies or provides protection for employees who work remotely. So it's really interesting. And I should back up and note that, the same, it provides the same protections or reinforces. It's the same protections under the prior law. A reasonable break time to express milk for a nursing child for 2 years after the child's birth, and of course the requirement that it be a private place where the employee can go to express milk is also encompassed with the Pump Act. So I wanted to point that out. But going back to the topic on remote employees, I think this is important to note because even though an employee is working remotely under the Pump Act, they are entitled to the same protections as an employee who would be in the office. So I think that's pretty important, especially in our post or current COVID world, where I think a lot of employers have really switched to a remote format, at least for part of the time. So definitely wanted to point that out. And if an employee is using time to express milk, they either must be completely relieved from duty or paid for the break time. So a little bit different. It's really one or the other. Either you're expressing milk or you're not. If you are, you have to be paid for the break time. And I should also mention that under the Pump Act and the prior law, the private space that is provided for an employee to express milk in the workplace cannot be a bathroom. So it has to be a private space. It cannot be a bathroom stall. There has to be a separately designated space. Now, if you're an employer and you don't have an extra office, an extra room available, you might be wondering, well, how can I comply with the law? I think one way you can look at it is you can use a space that is not specifically designated for expressing milk in the workplace 100% of the time, but you have to ensure that while an employee is using it for that purpose, that is the exclusive purpose for which it is used at that time. So if an employee is using the space to express milk, then everyone has to be aware of that and nobody can interfere with that. So I just wanted to note that as well. So I think that's a good rundown of the new federal law and the federal protections that are available for employees who are expressing milk or have the need to pump in the workplace. I wanted though to also note that New York State has enacted some amendments that are consistent with the Pump Act, but also actually provide more expansive protections. And if you're an employer in New York State, this probably comes as no surprise to you. So New York recently, at the beginning of this year, made some amendments to the labor law, or Section 206C of the labor law. And prior to the amendment, the law was very similar to the Break Time for Nursing Mothers law. These new amendments, I should note, go into effect June 7th of this year. So there's a little bit of time for employers to, again, take a look, educate yourself on what the law is, listen to this podcast, and try to figure out exactly what you need to do that you may not already be doing. So this amendment really provides expanded protections for employees who are expressing milk in the workplace. It is similar to the Pump Act, but I'll tell you how it's different. So As opposed to providing the 2-year time frame under the Pump Act, the amendment to the labor law provides up to 3 years following the child's birth. And I should note that under all of the laws that we've talked about today, this applies to the requirements apply to any time an employee needs to express milk in the workplace. So this isn't, a one a day kind of thing. These are the requirements and the accommodations that the employee must be afforded every time they need to pump. So I wanted to point that out. So let me tell you about some of the additional protections that this amendment to the labor law affords to employees who are pumping or have the need to express milk in the workplace. So the law provides that employers must provide a private lactation space that is in close proximity to the employee's work area, is near clean running water, is well lit, is shielded from view, free from intrusion from other persons in the workplace or the public, and that contains a chair, a working surface, and an electrical outlet. So obviously under the New York amendments, there are some additional protections that employers or accommodations that employers must provide employees, and the amendment to the labor law is very specific as to what those are. So again, if the space is not exclusively used for pumping, it can't be used for another purpose while an employee is using it for that purpose. Pretty straightforward. Another protection or accommodation afforded by the amendment relates to refrigeration. So the new amendments don't say that if you don't have refrigeration or fridges in the workplace, you don't need to run out and buy them for lactating employees. But if you do provide refrigeration in the workplace, so you provide refrigerators for your employees' lunches, drinks, things like that, then there must be a designated space for breast milk. So that's something definitely to keep in mind. If you have the means, the ability, you might want to consider putting a small fridge or a mini fridge in the lactation space, if it's possible. So one other, I think, significant difference between the federal laws we discussed and the New York law is actually under the New York law, there is no exemption from providing breaks to an employee based on undue hardship. So even if you could establish undue hardship under the New York law, that doesn't mean that you're completely off the hook. Undue hardship can be asserted for a reason not to provide a separate room or space for pumping employees, but it cannot be a reason to not allow employees to take reasonable breaks to pump. So there is an undue hardship exception, kind of, but it is different from the one provided by the federal laws. And I did want to mention that the law directs the commissioner of the Department of Labor to develop a model lactation policy. So that will be forthcoming. I think that there was a time period, maybe it was 60 days for the DOL in New York to issue guidance. So we'll see what they say about that. We'll see what that policy looks like. If you're in New York, you may already have a lactation accommodation policy. But I wanted to note that the commissioner of the Department of Labor is supposed to issue one under the amendments. And I did want to point out that there's also some new requirements with respect to dissemination of the policy, which is forthcoming. Specifically, you have to disseminate the policy upon hiring and annually thereafter if you're an employer, and to employees who come back to work following the birth of the child. So if you have somebody, you give them the policy in January, they give birth in June, they come back in October, that's pretty generous, but maybe September, August, you need to give that employee a copy of the policy when they come back to the workplace. So I hope that this rundown and summary has been helpful. I think it's a good explanation of the changes to the state and federal law as it relates to accommodations for pregnant workers. I think that we definitely anticipate guidance or additional guidance being issued both by the US DOL and the New York State DOL. But in the meantime, I just wanted to hop on here and give you guys a quick solo episode to let you know these are important changes. Last week we talked about, or a couple weeks ago, we talked about the Pregnant Workers Fairness Act. We're talking about the Pump Act. And I think these are just really important changes for us to note moving forward. So thank you so much for tuning in, guys. We really appreciate it. You can access the podcast on our website, on LinkedIn. Thank you so much for the support, and I'll see you guys in a couple weeks. The Labor and Employment Podcast is available on BarclayDamon.com, YouTube, and all your favorite podcast streaming platforms. Like, follow, share, and continue to listen. Thanks.